All right, so quorum being present, I'm going to call the Ethics Commission to its meeting. I'm going to call it to to convene. So the first order of business is approval of the minutes. There's actually two sets of minutes that we need to approve. One from our February meeting and the other from our more recent meeting involving a preliminary hearing. So do I have a motion to approve the minutes from our February meeting?
So moved.
Is there a second?
So moved.
Second.
All those in favor?
Aye.
All right, so, and then we also have the minutes from our March 23rd preliminary hearing that was conducted. Is there a motion to approve those minutes?
So moved.
There's a second?
I actually had to abstain.
From that one, yeah.
I second.
All those in favor?
Aye.
Okay, minutes are approved. So the next item of business is a request for an advisory opinion that's submitted by Nancy Albright. So Nancy, would you come up to the podium and so if you just briefly provide us with exactly what kind of guidance and advisory opinion you're looking for.
Thank you. This says push to speak. Okay. Thank you. I appreciate you all doing this in a quick manner for me. So as most of you may know, I was employed by the city of Lexington until the end of March, and I have since found employment. There was no prearranged agreement. I didn't know I was going to not be employed by the city on April 1st. But I have since been offered a job with a consulting firm that is based largely in Louisville, but they have a small office here in Lexington, and I've been asked to come aboard with the firm and help grow their business in Lexington and Eastern Kentucky. And as such, the firm is AECom. They have not done work in Fayette County in quite a few years, but they are hoping to help turn that around a little bit. And they have an ethics policy where they want positive confirmation in writing that there would not be a conflict or a restriction, or if there is a restriction, what are they before I go to work for them?
Thank you. So they do not currently have any business with the urban county government?
Correct.
No contract or anything?
Correct.
No.
The last project they had was the design for Town Branch Commons.
Okay, thank you. Any questions? So basically you're asking for our opinion regarding section 2511, which is the post-employment restriction.
Yes, sir. And I should amend my comment. I apologize. In the time since I left the city of Lexington and have hope to go to work for them, they have actually won. They've been selected as a project winner for a project. It's not been approved by council, so it's in that interim phase.
Okay.
But they have been selected for a contract with LFUCG.
Right, and I take it you had nothing to do with that?
I did not.
Right?
It advertised 2 days after I left.
Okay. All right, any questions for Nancy? So basically the post-employment restriction imposes a 1-year period during which you would not be allowed to negotiate any agreements with the urban county government. So you understand that? I
did not understand that. I guess that's what I was hoping to find out.
Yeah. So the restriction basically says that no salary officer or employee shall appear or practice for compensation before the government or the office in which he or she served with respect to any matter for a period of 1 year after the termination of the appointed officer's or employee's employment. So there'd be a 1-year period during which you would not be allowed to actively engage in any negotiations with that council. Is that right? Yeah.
Yes, that's my understanding.
Okay, so that would be the one restriction that you would have to follow in order to be in compliance with the Ethics Act.
Okay, when you say negotiate, or I guess, I want to make sure I understand what that,
Well, it says appear or practice for compensation. That's the terminology. So I would take that to mean that you are representing the firm in front of either the council or either one of the urban county government's departments regarding some business matter that the firm would possibly engage in with the city.
okay,
You would have to recuse yourself from that
okay,
for a period of 1 year. I think that would be my understanding. Would you agree?
okay.
I will
Yeah.
also add, I think we will prohibit that if your firm's like actively suing LMUCG as well.
Okay. So it is still okay to work on contracts for the city, but not to negotiate or present?
I would take that that's what shall appear or practice for compensation. Well, it says a practice for compensation, though, so that would be employment, wouldn't it?
I think it would be helpful to do additional research to vet out exactly what is okay and what is not okay, because this is her opportunity for livelihood, and so we definitely want to make sure we give the right advice rather than err on the side of caution. So rather than making a decision right now, if we could have further discussion on this to make sure if there are prohibitions listed, that we exactly define those prohibitions so we won't limit her from employment if that is a possibility.
Thank you.
Yeah, so I mean, what you would eventually receive from us is actually a letter that would be prepared by the law department that we would in various forms approve. And in that letter, there would be the kind of detail that Commissioner Turner is talking about, which would provide you with a lot of specificity as to what that 1 year period would be like and what would be the acceptable behavior or activities within that period or not so.
Okay.
Is that, you know, so, and we can work on that and prepare it for and get it to you as soon as possible.
I appreciate that. Thank you.
All right? Yeah, so, yes.
Okay.
So,
And I have a motion in response to this. I move that the commission direct LFUCG's Law Department to prepare a formal opinion letter which accurately reflects the findings of the commission regarding AO-2026-001. I further move that the commission authorize the chair to issue, as soon as possible, the opinion letter prepared by LFUCG's Law Department regarding AO-2026-001, provided that the chair determine that the opinion letter accurately states the commission's findings regarding AO-2026-001. Finally, I move that the opinion letter issued by the chair be provided to the commission for its review and ratification at its scheduled meeting immediately following the issuance of the opinion letter by the chair.
so I think if you remember, we talked about this motion in the past, so that this allows us to get a letter out more quickly than we have in the past, but it would still require the commission to review that letter and then ratify it at its next meeting, so. And that would actually be acknowledged in the letter itself, that the letter is being issued subject to subsequent review by the commission, but we will try to get that to you as soon as possible.
Thank you. I appreciate that.
Anything else on this matter?
We'll still need a second for the
Oh, yeah,
motion.
excuse me. We need a second and approval of the motion. All those in favor?
Aye.
Thank you.
Thank you.
How do you spell the firm's name?
It's an acronym, so it's actually AECOM.
So the next item on the agenda are the orders dismissing the complaints CO 2025-011A and 011B. If you've had a chance to look at those orders. If so, I will ask for a motion to approve the order dismissing CO 2025-011A.
So moved.
Second? A second? All those in favor?
Aye.
Aye, all right. And now I'll entertain a motion to approve the order dismissing the preliminary inquiry, CO 2025-011B. Is there a motion to approve?
So moved.
Second? Second? All those in favor?
Aye.
All right, both motions have been approved. And so I will, can I sign those? Do you have a copy that I can sign at the end of the, I don't need to do it now, but later. Okay. So the next item on the agenda are nominations. So these would be nominations that go to the mayor's office. Is that correct, Abby? Yeah.
Yes.
Okay, so we're not appointing someone to the commission. We're simply making a recommendation to the mayor's office as to who might be appointed to the commission. We actually just have one position, although there's 2 vacancies on the commission. We only have one position because one of the positions is specifically assigned to a particular organization which needs to make the nomination to us. The one position which is at moment at large is the replacement of our former illustrious chair, Jay Singleton. So that position now is an at-large position. So we have 2 nominees, possible nominees. It seems to me that we could send both nominees to the mayor's office and let the mayor choose, or we could select just one. I would have to inform everyone that Steve Rushell is a colleague. We served together on the board of directors of God's Pantry. So if you wanted to make just one nomination, I would step out of the room for that.
I also
that
need to
discussion.
step out of the room. Steve is a law partner of mine at Sites in Harbison, so I don't know if there's any role or thoughts or comment on having 2 people from the same law firm be on the commission. I don't know if there's any thought on that.
I don't know of any rule. I don't have any personal objection to that. Since I've been on it, I don't think we've had 2 people from the same firm, but I'm not aware that it's prohibited.
So how would you like to how would you like to proceed? I think if the commission wants to send both names up, then I think both Christie and I could sit for that because there's no selection to be made. If the commission would like to discuss the possibility of just sending one up, or the possibility of not having 2 members from one firm, then I think Christie and I would both step out of the room for that discussion. So,
Or we could punt and just note that Steve is with my firm, and if that's a problem, the mayor's office could decide. And we could just punt on the issue.
I'm comfortable with punting.
Okay, I vote to punt as well.
so the matter we would send both nominations to the mayor's office with a note or an acknowledgement that if Steve were to be appointed, Steve Rochelle would be appointed, we would have 2 commission members from the same firm, and make sure that that's noted. Is that, do I have a motion to that effect, that we send both names to the mayor's office?
So moved.
Is there a second?
Better.
Second?
I'll second.
Okay. All those in favor, signify by saying aye.
Aye.
All right, so we're going to send both names to the mayor's office for possible consideration of appointment, and we'll acknowledge the issue with law firms. So the next 3 agenda items are all about revisions to the Ethics Act, and I wanted to give you some background to this. To some extent, this is a little bit of emergency actions, trying to get something done. There is a board commission, a council committee that's meeting in June. Is that my understanding?
I think so.
Yeah, we believe that there is a council committee meeting in June that would be the committee that would receive such recommendations for revising the Ethics Act. So this meeting gives us an opportunity to get our recommendations regarding revisions to that committee in June for its consideration. And the three issues that are being addressed here is one, membership to the commission, and some issues regarding that. Specifically that the Ethics Act specifies some organizations that are no longer in existence to nominate. And then there's the provision about party affiliation and limitations on party affiliation. The second set of proposed amendments have to do with complaints and an initial review of complaints that are filed with the commission to determine whether or not we would have jurisdiction and how that would be handled, to avoid some of the stuff we've been dealing with recently, where we've had preliminary hearings where it was pretty clear what the results of that would be. That and then the third set of changes has to do with, let's see, here we go. The third set of changes have to do with who files the financial statement forms. There's actually two pieces in the proposed changes here. One has to do with not requiring candidates for office to file the year after they were candidates. So we've had problems with people who ran for office, were not elected, and we're still chasing down financial statements for them. So this would eliminate that requirement. And then the other one here was a consideration as to whether or not there are commissions or citizens boards similar to ours, which are making decisions of some financial or otherwise, but the members of those commissions are not being asked to file any financial statements. There's a pretty inelegant term here about judicial responsibilities. The suggestion that the law department has made is that we specifically list the organizations that are, what's the term in the thing? The
Quasi-judicial.
Quasi-judicial. We specifically list the organizations, the commissions, and the citizens board, which are quasi-judicial, for the requirement that they file a financial statement, and then perhaps put up at the end of that a provision that other similar boards, as they may be created and determined by the Ethics Commission, would also be required. So those are the three sets of changes that we're considering. So I think what I'd like to do is start with the first in regards to board membership, and the provision where we would recommend the elimination of the Professional Women's Forum as one of the organizations that would nominate and appoint a member to the commission, and that we eliminate Citizens for Ethical Government as the other organization that would appoint a member to the commission. And then finally, the provision that no more than 5 of the members of the commission shall be of the same political party. Those are the 3 changes there. So, discussion?
I don't disagree with any of those changes. I'd actually like to suggest at least one other.
Sure.
So since the time I joined, and I recognize I'm doing that thing where you show up late and start talking about stuff. It's graduation weekend, sorry. Graduation stuff weekend. But since I joined, it has been a rare occasion in which we actually had 9 people. And one of the concerns I've kind of had is that while our rules do state, if you look later in the rule, that we need 5 for quorum and 5 constitute a vote, that's really built on that 9. And one concern I have is about us taking official action when we don't have a 9-member commission. Not that we need 9 members present, right? Obviously, we have 5 as a quorum, but that I'm not sure in the entirety of the time I've been on, we've had 9. So a suggestion, a friendly amendment I might make would be to consider that instead of a definitive number, that we have a range. And whether it be no less than X and no greater than Y, it would give us some flexibility for those in-between times while somebody might be rotating off, somebody might be rotating on, somebody quits unexpectedly, we're, in the midst of dealing with or waiting on one of the orgs that remains to send us an appropriate nomination, just to give us a little flexibility. My concern with that is especially that when we are taking official action, it's one thing that we have a portion of our rule that tells us how many people we need in order to take official action, but we are out of compliance when we don't have a commission that has 9 people on it. And I worry that someone paying attention may take issue with that. So my suggestion would be that in paragraph 2 of section 2520, whatever. You missed all the good stuff, and I'm not repeating it. My suggestion would be that for section 2520, paragraph 2, that we consider the Ethics Commission shall consist of, for example, no less than 7, no greater than 9, whatever we want to do, open to discussion, open suggestions, in order to allow us that flexibility, and so that we are less likely to be out of compliance with the act in the future.
So I think at one point in the working of this particular section, there was a recommended change along those lines. So I would agree with you. I mean, I think it makes sense to have a range. So we would have to change the provision that 5 members constitute a quorum. It would have to be a majority of currently served members. That also would be a provision we'd have to change. So.
Well, it depends. If you left the min at 9 and a max, right? But I would suggest that we go lower. You could leave the 5 at quorum, but I would suggest we go lower, given that we have had the struggle to be at 9.
So keep the 5-member quorum, but have the range of what constitutes an official commission as either between 7 and 9. That's the recommended change.
Was that your recommendation?
Not officially. My comment was that we could keep the 5 if we left the min at 9, because 5 is obviously the quorum for 9. But we could lower it to 4 if we went to something else. But we don't have to automatically change it. The only reason I'm suggesting something lower than 9 is that we have had difficulty getting to 9. And if we went higher than the 9, then we would certainly need to change the number of at-large members, or add in another org, or do something, and that starts to get, I think, a bit more complicated. So I think I might suggest, if I may, a range of 7 to 9.
And I would be in favor of that as well, and based on the number of active commissioners, having a majority of whatever number of active commissioners to establish a quorum, rather than a random number of 5.
That's great. Yeah, and then if we have 8, yeah.
Any other comments or suggestions?
3 years ago, the 2 bureaus, the Better Business Bureaus in Kentucky actually merged. Oh. I guess I need to look down. Hello? Oh, this one, okay.
I was about to say, you better call him out too.
Right. 3 years ago, the 2 Better Business Bureaus in Kentucky merged. And so now there's only one, and it's just the Better Business Bureau serving Greater Kentucky. And I'm thinking maybe we need to change the wording of Central and Eastern Kentucky, because it doesn't exist anymore.
And I believe the Lexington Chamber of Commerce is now just Commerce Lex. I don't know if that matters, but.
Well, it should. So let's if we're going to go forward and clean up this particular section, let's go ahead and change the names of these organizations as they currently exist. Amend section 2 to state that the commission shall consist of a range of 7 to 9 members appointed by the mayor, so-and-so. And then I don't know where the section is that we'd have to look at the act where it talks about a quorum.
So so 2 things. I would say no less than 7, no greater than 9,
Okay.
rather than range of 7 to 9. And then you're in paragraph 12 of the same section to the presence of 5 or more members shall constitute a quorum. So that's where you'll want to change the majority. And then probably the same language in,
never mind, it's only placed, paragraph 12.
That's it. So those are the changes to this section?
The only thing that I'll say, I think historically, there's only been like maybe one or two boards with the no less than or greater than language, which I think is, the administration has found confusing.
I'm sorry to hear the last part. Is your mic on? I'm taking up this issue now. I have to entertain myself somehow. I'm willing to volunteer mine, if she would like.
It's turning.
So we don't have any more.
Can
This
you
is-
speak into that?
This is why we can't go higher than 9, because we don't have enough
Right.
mics.
I think just the one comment I'll make is that there's been one or two boards with that same language, no less than, no greater than, and I think the administration has found it to be confusing. In that it's difficult to determine who actually, like what the number of people are that can be appointed to the board. That's the only comment that I have about that.
I would, yeah, so it doesn't seem confusing to me, so that would be
Same.
my reaction. I think it's,
I have faith in the clerk's office to be able to keep it straight.
yeah,
I think we can do it.
yeah,
Well, now that my microphone's working.
I think we're up to the task.
Welcome.
I think we can do it.
okay.
So I have a question.
Yeah.
This must be ratified in a referendum, correct? That changes to the Ethics Act?
No, it's not part of the charter. The Ethics Act is not part of the charter.
Okay, so council can just change
Yeah,
this?
the Code of Ethics is part of the charter. That's the, so we have the Ethics Act and we have the Code of Ethics. The Code of Ethics is part of the charter. So to do anything with the Code of Ethics would require action under the charter.
Okay.
Yeah.
So this just requires a majority vote by council?
I think so, yeah.
Okay. I was just asking because it seems like a lot of these names of the organizations rotate a lot, and I was wondering if there was a mechanism to put in place that would make it less daunting to have to keep updating this. I mean, maybe it's good we have to update it in a daunting basis. But, yeah, I don't know, I was just thinking about that.
I would say I agree with you. I don't think they change that often. I think we just haven't updated it in quite a while, but I don't think it hurts for us to be motivated to look. I'd like to note that the Lexington, the League of Women Voters Lexington has kept their name. We're feeling pretty solid about that. The other thing, if I can just make one other comment, would be, it's my understanding, I'm not the one that has to deal with these pieces, but it's my understanding that it has historically been a bit difficult to get the nominating organizations to turn in the things, not just to send us nominations sometimes, but to send in the paperwork and pieces that that our staff need in order to do their job. So, I mean, I welcome commentary from the people who actually are boots on the ground to do this, but I might suggest that instead, the way that those submissions are split out in the code is a little bit confusing. I might suggest that in our section where, in 9, where they are being, that's a bit more of a shall language, and also that it has to be updated, at a minimum, it has to be updated at the time of a nomination. But I would leave it to our folks to please comment on what edits would be more appropriate.
We would definitely prefer that parenthetical 9, that number 9 would be incorporated into the requirement for the nomination for the nominating organizations, because we query this information on a rolling like on a calendar every 2 years, and it's been 4 years since anyone has sent us anything. So we try to get it. We can't strong arm anyone we can't make people give us the records that we're supposed to keep. So we do our best to get them, but nobody gives them back to us. In fact, we just sent out to all the nominating orgs. We solicited all of this information about a month ago, and we have not received anything yet. So it would be best if we put all of these requirements into the requirement for the nominating application, basically. So at the time of nomination, they are, required to send all of this information, and that it's sent to the mayor's office, so the mayor's office can see it as well, because that might actually, I'm sure the mayor's office would like to see this information. I don't know why it's sent to us and not the mayor's office. I'm sure there was a reason at some point when they did that, but I think it makes more sense for the mayor who is making the final decision to who she's going to appoint, for her to be able to see this information.
And I would say, especially because we do still want it updated regularly, because the
Yeah.
other thing is that if we include it solely at the time of nomination, it's going to always be 4 years out of date. So if we leave the portion in that requests that the chair shall request the updated information no sooner than 1 year, no later than 6 months after the relevant member's term, and we do it at the time of nomination, then you're at least only 4 years out of date. But if there have been updates, I think we could include an ongoing obligation to update us, or to submit that information. But I would certainly second and agree that the information in paragraphs 9A through at least 9G be incorporated in, or at least referenced in 6,
Yes.
to say that they
What-
shall
what
be
if we-
included.
What if we added a sentence to section 9, which says that this information shall be provided at the time of
I think you need to
nomination?
add something into 6 as well. So I'm cool with adding a sentence. You could leave 9 where it is, but I do think you should add something into 6 that says, at the time of the nomination, information in subparagraph 9 must be included for a nomination to be considered valid.
All right, would that work? Yeah. Okay. So is everyone clear on the changes to this particular section that we are considering? Do you want to run through them again? So we're eliminating subsection F and G. We're changing the 2 members at large to 4 members at large. We are adding language, let's see, so where are we? So we're adding language to paragraph 6, right? Which references paragraph 9 as information that needs to be provided at the time of the nomination. We are changing, oh, sure, yes.
What were the names of are we also changing the names of the nominating
Yeah,
organizations?
oh, thank you, yeah.
Sorry.
So we're changing the Business Bureau of Kentucky and also the Chamber of Commerce name, Commerce Lexington, okay?
Is it the Better Business Bureau of Kentucky or Better Business Bureau of the Bluegrass?
It's Better Business Bureau serving Greater Kentucky.
There you go. Or no bluegrass in there at all. I just made that up.
We have a little bit of Indiana too, so.
Okay, and we were changing paragraph 12 over here. That's the recommendation, changing
Yes.
paragraph 12 to say, what was the
The presence of a majority of members.
majority of members? Is that,
And
Christie, is that it?
Yes, I believe so.
Yeah, so, so no,
the political party.
no, and eliminating political parties, thank you. And no less than 7 and no more than 9, was that the language? No less than 7, no
Yes.
more than 9.
Sorry.
Okay, so those are the, is everyone clear on that what we're voting?
Can I make one more suggestion, because we're on a roll?
No, you can't.
Too late. I haven't met my minimum suggestions for the meeting, Chair. I'm wondering, just looking at paragraph 12. So most of paragraph 12 talks about definition of official action. We did the majority quorum, blah, blah, blah. The part at the end, adoption of minutes, all of that, the very last paragraph last sentence kind of is thrown in. Any member of the Ethics Commission who shall, a conflict of interest with respect to any matter, shall disclose the nature of conflict, shall disqualify himself, and shall not be counted for purposes of establishing a quorum. I wonder if it wouldn't be a good opportunity to add some language that indicates an ongoing responsibility for all of us to continue to declare conflicts of interest, not including but not limited to financial interests on a regular basis as necessary at each meeting, something like that, which might mean adding a paragraph 12 A or making that 13 and making 13 14. But I think it would be a good opportunity to indicate that, especially given some of the other discussions we've had about conflicts and ongoing obligation.
My experience, the way that's handled is that the question is asked at the beginning of every meeting. Does any member of the commission, in this case, have any conflict of interest regarding any of the matters before the commission? And we could put that language as a last sentence, that the commission meetings will begin with a request for possible conflicts of interest.
Yeah, I don't think that's a bad thing. I guess, though, that strikes me as something that's a little bit more style, and I think I'm looking for something that creates for lack of a better phrase, an ethic, like an actual obligation on members to update their own conflicts, disclosures, not just at individual meetings, but to update them on a regular basis. You're the expert in this space. Can you chime in, please?
I think I follow, but we already have the obligation to disclose financial information, just like everybody else. But when you're saying, for instance, I have recused from matters over the period of years, but there's no defined reason for the recusal. It's not like having a 1.7 current client conflict that is defined with 27 subparagraphs of description of how that works. It's for me, if anyone in my law firm is involved in any issue, any aspect of any issue that comes, I always just recuse. Are you saying that we should give some sort of definition as to what beyond some sort of financial interest would necessitate or a disclosure or a recusal?
I wasn't. Now I'm thinking about it, so good job. But what I think I more had in mind is the time that we typically file, like our financial disclosure, is at the time that we are joining. And from at least what I recall of that form, there is not explicit obligation to update that form until you are at your next term. Is that correct?
I think I fill one out every year.
Well, every year, but I mean, but what I'm saying is that in each meeting, so I think what David is saying is that you're asking that we include something.
Yeah, because what Carrie just suggested is different than providing information about financial interests. It's something else. So the disclosure requirement for financial statements is annual, and if there's changes. So we're under that obligation. Now, we may not follow it, but we're under that obligation.
Yeah, which is why I'm suggesting we add.
What I'm familiar with and other organizations I've been part of is that you ask that question at the beginning. I mean, sometimes,
Yeah, and I guess, David, what I'm saying is that in the event somebody forgets to ask, the obligation still lies with us.
Well, you make it a standard agenda item. This is the way it works. I mean, the first item on the agenda is you ask all the commissioners, do any of you have any conflict of interest regarding the matters before the commission this evening?
So I think there's two portions to that. I think it's great if we add that in, that we make that agenda item. I'd love to add that. I think, though, you have to have the matching obligation back. So if there's an obligation to ask, there should be an obligation to answer.
The reason I think that is a good idea is because when it was asked this earlier about if there was a conflict, it didn't occur to me at that time to say something about Steve Rochelle. But when the issue came up, I was like, oh, I got to say something about Steve Rochelle.
So we would at the end of this paragraph, we would put two things. One is that the commission agenda would include at the beginning of every meeting a request to identify any conflicts of interest regarding the matters before the commission, and that commissioners are obligated to ensure that they have reviewed the agenda and the matters before, and that they disclose. So
I think that sounds great.
Yeah, that kind
to me, maybe not to Carrie.
But I reviewed the agenda. I just forgot.
What?
I reviewed the agenda.
Commissioner forgetfulness is no excuse.
I will just add that it's important, I think, to make sure to get that out to people in advance. Sometimes there is, are you going to be able to be at this meeting without knowing what's going to be on the meeting? And so the earlier we can find out, what's going to be on, and obviously things can change up to the minute, but I do try to look at that as quickly as possible so that I don't blow a quorum or something. I can find out quickly whether or not I've got a problem. But anyway, that if we can be careful about that, it makes it easier for us to go ahead and announce, because I don't want to waste people's time, and I don't want to come over here and then have to leave. And
I think that will also, in combination with the change we made for the 7 to 9 and the majority, that will help balance that out a little bit, right? So if that did unfortunately happen, we've still got a little more flexibility.
Yeah, the conflicts are most likely to occur in regards to either requests for advisory opinion or complaints. So the normal ongoing business of the commission is rare. So and those are easy to kind of look at as quickly as possible and get them out. So is there anything else? Anything else? You're not allowed to.
I'm not sure why you're looking over here, David. No, that was all I had.
So what I would like to do is to entertain a motion to, and the motion would be to recommend revisions to section 2520 of the Ethics Act. Those revisions that have been discussed and agreed to so far.
So moved.
Is there a second?
Second.
All those in favor?
Aye.
So I'm counting on council to have captured all of that, so thank you. Because I think I have most of it. But,
Got it.
Okay. So I'd like to change the order in which we're considering things a little. I'd like to just go to the financial disclosure, who must file the 2513, section 2513. And again, as I suggested, there's sort of two pieces to this. One is to eliminate the requirement that candidates to office submit another financial statement the year after. So that's on subsection 5. So we just say that it's 1, 3, and 4, and eliminate 2. So that's the one. And then the other one is this provision that we're going to expand the requirement to file to other commissions and citizen boards similar to ours, which have, and that Gabby, you have a list.
So I believe I think it's Commerce Lexington that came out with a list. I'm not sure that it's all comprehensive. However, they did come out with a list of quasi-judicial boards, and I can briefly read that. It's the Administrative Hearing Board, the Board of Adjustment, Board of Architectural Review, Civil Service Commission, Courthouse Area Design Review Board, Environmental Hearing Board, Exaction Appeals Committee, Fire Pre-Disciplinary Review Board, Historic Preservation Commission, Infrastructure Hearing Board, Internal Audit Board, Planning Commission, Police Disciplinary Review Board, and Rural Land Management Board, Vacant Property Review Commission, and the Water Quality Fees Appeals Board.
So that's going to dramatically expand the number of people, filing financial statements. So originally the language here would give us some discretion as a commission to designate. We might do it on an annual basis to designate some of those groups to file, but not necessarily all of them. So I mean, I'm kind of in favor of coming up with language that suggests the requirement has to do with decision-making authority of some form or another, and that the commission has the discretion on an annual basis to review those commissions and citizen boards that are required to do that. And then what we could, at a meeting, we could have somebody present all those boards and take a look at what they do and decide if some of them are not filing we could ask them to begin filing because of their responsibility, as opposed to injecting into the Ethics Act all those names. So does that make sense? So I'm not quite sure what the language is. I in a rush, came up with adjudicative responsibilities and was hotly criticized by the legal department for
I did not.
for such
It's a tough group,
not
David. It's a tough
not
group.
Gabby, but for such confusing language. So but it is, so I didn't know what to put. So what does anyone want to?
We're in fan of more review on this section. I mean, if we're adding boards and more like boards and commission members, I think a review of city government in general, because when this was created, the city looked a little different as far as how it was structured and what kind of divisions were in there. And there are a lot more positions now that deal with money, that deal with awarding money to different organizations throughout the city that I think should be included in this. So I'm a fan of more oversight as opposed to less, really. I mean,
Well, that we would have that if the commission on an annual basis were to review.
Yeah.
Yeah, so.
and I think as far as like logistics go, for us to be able to send them out, I think a review should probably be done at least in August so that we have time to, really take a look at who, if anybody needs to be
Right.
left out or put on the list that we send out, because we send it out in the first week of January. So we would need an updated letter, an updated form, perhaps, or maybe not, but just an updated list of people.
Yeah, so the meeting, our August meeting could have as a standing agenda item, a review of those commissions, citizens boards, and functions within the Urban County government
Yeah.
in regards to which a filing of financial statements should be required.
Would we want like Melissa McCurt-Smith to come to that if she could,
Yeah,
and help us give maybe a presentation or something?
okay. So does that make sense? We would just,
Yeah, that makes sense. I think I agree that the additional oversight, not that that was a particularly sketchy group of folks listed that I'm super worried about, but I think the more the better. I think having folks also feel and take seriously the
Yeah.
idea of conflicts and disclosures, I
Yeah.
think makes a lot of sense.
Yeah.
And I would second the idea of having us take on a specific task to officially review that on an annual basis in a time consistent with making sure that those disclosures are made and turned in appropriately.
So that's those are the two then changes to 2513. One is to eliminate the requirement for candidates subsequent to their candidacy to the following year to file, and then to have a provision that there will be other commissions, citizen boards, and individuals who
So-
will be required based on a annual review by the.
Yeah, so David, I think that means then from paragraph 3 in 2513, right now it says, have adjudicative responsibilities which determination may be made from time to time by the ethics committee. I think we need, or commission, I think we need that language to say, which shall be made on an annual basis by the ethics commission.
Yeah, there you go. All right. Are we clear on what we're voting on 2513?
Yes.
Okay. So could I have a motion to approve those changes to 2513?
So moved.
A second?
I will second it. I just have a quick question.
Sure.
And this is probably just my ignorance from being a newer member. What's the process with the financial interest statements in terms of the Ethics Commission? I just want to make sure that if we have this,
We're going to talk about that
okay,
in a second, so you
Okay.
have that, yeah.
then I will
Yeah,
second this.
Yeah, yeah. Thank you. All those in favor?
Aye.
Aye, all right, that's passed. Okay, so the final section for us to consider is the one that has the most extensive changes to it. And so just as a kind of quick summary overview, what this is suggesting is that when a complaint is filed, the chair will review the complaint and make a determination as to whether we have jurisdiction specific, we have jurisdiction relative to the provisions in the Ethics Act, which provides that we don't have jurisdiction over those individuals. The chair would not have discretion to review the factual claims in the complaint. There's a determination that's made in the preliminary hearing, not just to whether the commission has jurisdiction, but whether there's sufficiency of allegations or sufficiently of fact to go forward with a full hearing. I think the reason for not allowing the chair to make that determination is that you could get a complaint which is kind of sketchy on facts, but when the complainant comes before the commission and we ask them to make that initial statement, they might reveal a whole bunch of stuff that really makes the complaint more compelling. So the idea here is to allow a complainant to have sort of their day in court in regards to the factual. But if there is in fact a complaint against those individuals for whom we do not have jurisdiction to hear a complaint of a violation of the Ethics Act, the chair makes that determination, communicates that determination. It would be, it says here to the commission, but it's to communicate that, that made that determination. And then it's reduced to writing and it's sent to the complainant that determination has been made. That determination then comes to the commission at its next meeting for the commission to review whether in fact the chair was right in saying that the commission did not have jurisdiction, and the commission ratifies that. If the commission decides that it was a mistaken determination, the commission then can issue that a preliminary hearing be held in that process. So, yeah.
Yeah, totally agree with the idea of changing. It's been very disappointing, and like Carrie was saying earlier, just such a waste of folks' time to drag them here only it just frustrates people to then be told we don't have jurisdiction. And if I were them, I would be saying to us quite often, you really couldn't have figured that out before, right? So I think this is great. My question is in B, first paragraph under B, if the chair determines that the commission does not have jurisdiction to hear the complaint, the chair's determination shall be reduced to writing and transmitted to the commission. The commission shall acknowledge receipt and transmit a copy of the chair's within 10 working days. So I guess my question though is, how is that working if so you're doing that?
It's a good question. So I'm wondering whether it's.
Because you said next meeting, but.
Yeah, I make the determination and I communicate it to you. I mean, and that you reduce it to writing and communicate it out. But what's communicated out is CC to the commission in some communication?
Well, yeah, I guess I'm wondering though how that's working. So if you're saying no, we don't, right? We don't have jurisdiction. Yeah. They're communicating that to the complainant, but it's waiting until we next meet for us to be able to vote that we agree or disagree.
Yeah, that would have to be the case because the commission can't take an action on basis of an email or whatever. We would have to, and again, do you want to convene a commission meeting just to confirm or ratify the fact that we don't have jurisdiction, let's say, over a police officer? So, yeah, so it's.
No, I was just trying to think through the logistics of that in the real world, right? Not on paper, but how that plays out in terms of then what happens after that. Or if you say that we, it's pretty easy if you say that we do and then somebody gets here and then we disagree with you, we say they don't, but now they're back here again. Now we're back in that boat again. That's my only question, is just how the logistics work. Does that make sense?
Yeah, I mean, could there be some sort of not to overcomplicate this, but chair advisory opinion, and it's officially confirmed upon vote by the Ethics Commission, so they can proceed with, quickness, saying, well, the chair said that they don't think that there's jurisdiction here, but I know that it's going to be confirmed at their next meeting, so that it kind of has the meet in the middle of both.
Because if you say yes, then they're technically coming to the next meeting, right? That is when their complaint would be heard. At the same meeting they're coming to, we're still doing the jurisdictional agree or disagree, which to some degree makes sense. I don't know. I just want to be thoughtful about how that's playing out.
I'm not clear on what you're worrying about. Is it that you want, if a chair determines that there is jurisdiction or the chair, so I'm just, okay.
Well, it says the commission shall also forward a copy of the complaint, transmit a copy of the chair's decision regarding jurisdiction to all alleged violators within 10 working days after the chair's determination. Chair's determination shall be included on the agenda of the scheduled commission meeting immediately following the chair's determination. I just want us to think through a little of what that's going to look like in terms of that complainant and all of the alleged violators would be here at the same meeting that we are then discussing whether we agree or disagree with the chair's decision that whether there is or is not jurisdiction. Is that right?
Well, I think that would only come up if he's said that there was jurisdiction and that the person came to the next meeting, and then we arrived and said we disagree. If he said that there was not jurisdiction,
We'd still be reviewing it at the next meeting.
we'd be reviewing, but
then their
they
complaint.
would not be there.
So I think my logistics question, though, is how does that work with the other parts of the act that have issues about time?
The time, like the time frame with.
Yeah,
that
so
you
if he
have to
says
hear
there's
it.
not jurisdiction, right? And then at our next meeting, whenever that is, it could be a long time, could be a short time.
2 or 3 months, yeah.
We say there, we have that discussion and say there is,
So,
what's the statutory
Yeah,
implication
so I
of
think
that?
changing the Ethics Act changes that timeline in regards to when things have to happen. So it's not as if we're under the same time constraints that currently exist in the Ethics Act. If we amend the Ethics Act to allow for this, it sets up a new kind of.
Yeah, I think what I'm
schedule.
asking, though, is are there other provisions that aren't necessarily edited here, but might need to change because of that?
Provisions regarding the timeliness in which a meeting is held, or notifications, or,
Yes.
yeah, I would say that there should be language in here about how long the chair would have to make that determination. If it's not already in here, it says within 10 days that you will let the other person know, or the chair will
Yeah, you got
You
10
know,
days.
yeah, so there has to be some sort of, I think probably some sort of within X amount of days, the chair will make a determination. And then if it's determined that it does meet the requirements to come before the Ethics Commission, then that puts in motion all of the other things that already happen.
So the way I kind of thought of it is that if the chair determines that the commission does have jurisdiction, that starts the clock. That starts, so that the time in which the commission has to have a hearing of the complaint begins when the chair determines that the commission does have jurisdiction.
So maybe definitely put language in there about how long the chair would have to make that determination.
Sure, yeah, you can do that. The chair needs to,
Also, I don't see anything in here, or maybe I overlooked it. The allegation has to have occurred within 1 calendar year of the complaint. So, and that's pretty objective. That's not, left up to interpretation. I think that could also disqualify a complaint if somebody submits something and it happened 5 years ago. That's going to be, that historically has been dismissed before.
without a preliminary hearing.
Well, it's been but that's been a reason it has been dismissed at a preliminary hearing.
Is that the lack of minimal factual basis part?
I don't know.
I would assume that or the frivolous component.
It's been some years since I've had this conversation with Evan, but it was within jurisdiction, within 1 year of the complaint, and minimal factual basis. So those 3 things had to be satisfied before the inquiry went to a hearing.
And then we'd also need to change in paragraph 3. It says the commission votes to consider the complaint pursuant to 2523 1C3 or 1C. It's actually, there's no longer a C. So it looks like it's B. That it would be pursuant to us deciding, is that correct? So on paragraph 3 on page 23,
Yeah.
it says the commission votes, Ethics Commission shall conduct a preliminary inquiry within 30 working days after the chair's determination, the commission has jurisdiction, or the alternative, the commission votes to consider the complaint pursuant to 2523-1. It's a C. I think that should be B,
Because there is no.
because there is no C.
Yeah, B. But again, look, so that's what I had in mind when I said the chair's determination starts the clock.
Oh,
So,
yeah, I
yeah,
know. But what I was thinking was, that's partially why I was thinking about the logistics, given that it also matters if we disagree with you,
Right.
then your determination starts 1 clock if you say yes. But then the question is, if you say no, but we disagree with you at the next meeting, that actually starts a different clock.
That's right. Yeah, that's right. So,
So if he says no, could we just schedule a quick Zoom? And then if quorum's just going to be 4, I mean, you could do the. that
I
would
think
be
if he
easy.
says no, it goes on the agenda for the next, if he says no, then that doesn't start any clock. It goes on to the agenda for our, now it's doing it to me, to the next meeting. And then if we say yes at that meeting, that starts the clock from the 30 days from there.
that's right.
So it puts the person on hold on a little bit of a kibosh, but we're not outside of the act at that point.
Yeah, in a sense, these changes actually set up a new timetable for things. So it's not as if we're making these changes and operating under the current timetable. It's setting up a new timetable, and it's setting up new triggering events for that new timetable. A determination that there is jurisdiction, or determination by the commission that the chair's determination that there isn't jurisdiction was
Also,
mistaken.
it's
So-
faster to get a response as to whether there's jurisdiction. It's slower if he says no, but we disagree.
Yeah. Yeah, so given the limited determination, I mean, the limited scope of that determination, I determined that the respondent, we do not have jurisdiction over the respondent because I've gotten information from the law department as to the current status of the respondent, and it turns out that they misinformed me, and, so, I mean, those are the kinds of problems that could arise, but it's a straightforward thing. I mean, the classification of individuals over whom we do not have jurisdiction to hear complaints about possible violations of the Ethics Act is very definitive and limited. And so that's the whole point of being able to do this. It's a really easy determination. We've never had problems, so we're trying to get this done in a way that short circuits, putting together the apparatus of a preliminary hearing in order to make something that's rather straightforward. So there's 2 timetables here that's suggested that eliminate the timetables that currently exist, so.
I think I had one other question, though. So moving ahead to paragraphs 4 and 5. So for 5, if the commission concludes based upon its preliminary inquiry that the complaint is within its jurisdiction and contains allegations sufficient to establish a minimal factual basis, shall initiate a formal hearing. So I haven't experienced one yet where we've moved it forward. So we're envisioning at this point that the previous structure would have had them coming in once, which sometimes is a jurisdictional question, doing a preliminary inquiry, and then potentially moving forward to a formal hearing, which may be 3 things. And here we're narrowing it to 2. Is that correct? Okay.
What was the 3? When you said it was initially 3?
Well, I guess one of the things I thought, so you've got the jurisdictional piece, right? So people coming forward, and we can sometimes we were doing the preliminary inquiry if we said yes then, and then we were sort of blending those, right? Other times those were sort of separate things. And so people came back, and so it was 2. And then if it moved forward, there's a formal hearing. I guess I'm just also want to envision a little bit what we see as the difference between the preliminary inquiry and the formal
There's
hearing.
procedural differences, I mean, in terms of taking testimony and that sort of thing, so.
Well,
yeah,
I
so-
think given that we also have newer members and most folks have not made it through those, it's probably a good idea to,
Have
to
we
walk
had-
through it.
When was the last time we had a formal hearing?
We have never had a formal hearing
There
as
you
long as I have been in this
So we're all-
position.
Yep.
Yeah.
Which
yeah.
is why I was asking the question.
Yeah.
Yeah.
And we have looked back through our records. Has there
like one,
We've had
maybe?
one, yeah. And I don't remember what year it was from, but it was,
Yeah.
it's not been
Yeah,
recent.
so. Which is, sort of, there's much to do about this whole section and responsibility of the Ethics Commission, and it's something that, anyway, so.
So I think that I like these changes. I do think that I agree with what you said about, people coming here unnecessarily. I also agree with you, Chair Blake, about being able to get people answers quicker. My concern would be if we did have a chair that was not as fantastic as you, that, was not as diligent in looking at facts.
Yeah.
And you said that you get consulted by the law department, but I'm not seeing that exactly here. So theoretically, we could have a corrupt chair who dismisses things, and then we don't have a say until months later. So your point about like a quick Zoom meeting, could we just have language that says by the petition of any single member on the Ethics Commission, it would trigger?
I think the issue is
That-
they have to be public. Yeah, they have to be public for open records. So the problem with the Zoom is you have to give notice to the public so the public can attend. So that's why we can't meet via, we can't discuss formal things via email.
Yeah.
And yeah, that's the whole, I agree with you. That's the holdup. I think though that I'm feeling okay. I was with you. I was kind of thinking the same thing on the good folks, bad folks in terms of whatever. But I think as long as it's being tracked, it's still coming to us for review. So on one hand, that's why I said before, I think people are going to get a jurisdictional answer faster, which is good. The part that may be slower, depending on when it's coming in, is if we disagree. So on one hand, so I think overall it's better, and as long as the department is still tracking it, and we're still going to know about it on an agenda, so we won't lose anybody. So even if we had a corrupt person who was just saying no, 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 it's still all coming to us. It just means those folks might be a little more delayed than they were before. Am I thinking
Yeah,
that that's
I
the
think-
procedure? Is that right? Or
And
That's right,
A
yeah.
while, I suggested to involve the citizens advocate as well as like part of the review process when we would get a complaint, because that's a third party. It's kind of outside of our office, law department, or the commission, so they could.
you mean in the jurisdictional determination to include that person then?
Yes, just to have them kind of maybe even just whatever and it could be like to review the chair's opinion that it's outside of the jurisdiction, just another set of eyes on it to say, yep, I agree with this, or maybe not.
So, I mean, this is such a straightforward thing. It seems to me that, what we want to do is uncomplicate this.
And I think I agree with you. It's always nice to have more folks, and it might cover what he's suggesting. I think the downside, I don't know the answer to whether when it's two people and you're having a discussion, whether that is subject to open records too. So I think that might complicate. And I do agree, the jurisdictional piece is pretty base facts, not facts of the complaint, but base entry. So I don't think we're going to be missing much.
Yeah, I agree. And I know that this is being super complex. I would just hate if there ever was a discrepancy and someone takes action based on that, and then the Ethics Commission is like, actually, we do have jurisdiction and we're correct, and then it's like, then what happens? How do we undo what might have happened?
Well, when you think about it, the subsequent review of a determination that there's no jurisdiction is really kind of it's got to be a straightforward thing, what's the review? I said there was no determination, no jurisdiction, it's a police officer, so that's it. I mean, that's the review, so it would.
Also, remember, I think maybe you're thinking of an advisory opinion, and they would act on the fact that we don't have jurisdiction, but that's not what this is in the context of. This is in the context of a complaint against somebody else for having done something, so you wouldn't rely on us not having acted in doing something in the future. It's just that your complaint wouldn't be heard at that moment anyway.
Yeah, and the issue with a corrupt chair, I mean, you would have a couple of instances where there was a determination of no jurisdiction for no basis at all, and the commission would review both of those, let's say, and at that point in time, the issue isn't with the ethics action complaints. The issue is with getting rid of the chair. So I think that there's a fail-safe here. with the review. I mean, again, you're reviewing something that's straightforward, so when you think about it, it's, the determination by the chair is straightforward, the review is straightforward. So I don't think that there's, much chance of things going wrong here.
I will just say in the world of lawyer complaints and discipline, there is such a thing as a dismissal without investigation that is done immediately upon receipt of a complaint that fails to state a violation of the rules.
Right.
And that's even an analysis of what's being complained about. And there's not a problem, there's not been a problem with that. But generally, the bar is very, very low, and things will, it's a different system, but the ability to, I think it's important to be able to not have these proceedings. It may be as many as 10 to 15% of these that I've been involved, maybe it's more than that, have just been known going in that we have no jurisdiction, and we listen to a lot of stuff and then adjourn for a moment and confirm that we have no jurisdiction and tell them. So, I mean, it's already known before the meeting by everyone that we have no jurisdiction. So there's got to be a solution to it.
I would say that I disagree with Gary on the efficiency and goodness of the lawyer self-review process, but this actually, we'll fight about it later. But I do think here, though, that everyone is right, that this is really just the jurisdictional question. It's not getting into the substance of it. And because we're already building into the next agenda, I think all that's there. I think all we're doing really here is eradicating frustration by people who came and vented and then got told no. I think eradicating that will do a lot in the direction of public trust, rather than people feeling like, they said their piece and we went like, yeah, just kidding, we don't need to hear that. And there is that fail-safe. So I think actually, as Carrie was saying, if you like that lawyer structure, this is actually got a bigger fail-safe in it, in that it's coming back and being reviewed again, which we generally don't do in other spaces for disciplinary review. So I would suggest, unless other folks have stuff, I'd be happy to make a motion to approve the discussed changes with the friendly amendment that we also edit in paragraph 3, changing our lowercase c to a b.
Yeah, but also to put in a stipulation as to how much time the chair has to make this determination, so.
I think we actually already have that in there. Like,
so-
it says 10 days, that he has 10 days. Or are you suggesting in sub B under 1 that
Yeah.
needs to say that also should be a 10-day?
Or just, if we're sending out a letter to the complainant within 10 days, that the chair should just back that up a little bit and say the chair has X number of days to review and make a decision. And that basically, because I'm assuming that the law department would be drafting that letter, so the
Yeah,
law
your 10
department-
days begins after the chair's determination. So you've got 10 days from the determination. So you're saying you want to give the chair a time frame by which to make a determination as well?
Right, yeah.
Okay, gotcha.
Just to kind of spell that out, yeah.
Do you have a suggestion, Chair, as to what would be an appropriate response time?
So it's just, 24 hours, no, it's just, it's
Yeah, we're going to say no.
So I don't know. I mean, we could have it as, as immediately or within a reasonable amount of time, or.
I mean, open records is 5 business days.
I was going to say 5. I don't
Okay.
think we want to do,
5.
just having a lawyer moment here, things that require additional interpretation of what's reasonable and what's timely. So 5 sounds
5.
reasonable and timely.
5.
So just for clarity, should it say sub B, sub I, within 5 days from receipt of the complaint, sorry.
I think it's B that you want to make the change to.
Right, yeah, the
Just
chair of the
B, not
commission
sub
shall,
I.
the chair of the commission shall review within 5 business days.
Within 5 days
Yeah.
of receipt of the
Yeah,
complaint.
that's
Okay.
that. That's it.
5 business day, thank
Yeah.
you.
Okay.
Not calendar. All right.
I will accept that friendly amendment to my motion.
Second.
Okay. So is there a second to the motion to approve these changes?
Second.
All those in favor?
Aye.
Aye, so, all right, so we're gonna, we're gonna see what happens when this goes up the chain of command and what kind of response we get back. So the next agenda item has to do with financial statements, financial interest statements. Previously, I talked about my kind of informal review of the 100 and some financial disclosures and what I discovered in that and some of the curious features of those disclosures. A couple of things struck me. I wondered whether the form itself was adequate to inform people as to what this was about and what information we wanted. And then I also wondered whether there were some instances where some kind of form letter might be an appropriate response to what's being disclosed. Maybe not, for everybody, but what I thought is that I would very much like 2 other commissioners to take a look at what these disclosures, what these statements look like. And then for the 3 of us, and it'll be Christie and Carrie and myself, the 3 of us meet after we've had a chance to review a portion of this and discuss that. That is, would the process benefit from some changes to the form itself? We can do that. The form is whatever it is. And then, is there any need for us to respond to some of the disclosures we got? I was particularly struck by the fact that we have quite a few individuals with working spouses, with financial interests, real estate property and the like, but out of that 100 and some disclosures, there are only 3 people who identify that they might have a potential conflict of interest. So people aren't understanding and reading exactly what that last question is about. So what I was proposing is that once we get them in, we will divvy up the disclosures, maybe about 30, 40 apiece. We review them. You can provide them. We'll divvy them up. And then the 3 of us can come to a meeting, an open records meeting, and we can talk about what we saw in those disclosures and whether there needs to be some possible changes. And then we come back to the commission with whatever recommendations we might have. So it's a review of this process that we've not really done before. So that's the idea here.
I think that sounds great. I love that. I love also that I'm not doing that. Just two things just to think about adding to that, to your point, David, about people not really understanding it. I wonder if a little bit of the language there, it's financial disclosure, not just conflict, that we're not including just the phrase like conflict of interest, because those can be 2 different things. So maybe we want to consider whether changing the name, adding that language. I'd also love on the form to have people above where they are signing, have us sign that we are acknowledging a continued obligation in between times, right, in between the annual reviews to update as anything changes for ourselves and/or for spouses, immediate family members, et cetera. I'd love to add that. But I really do think the conflict of interest language, in addition to it being a financial disclosure, because there are plenty of conflicts that exist that are not necessarily financial.
And the form is pretty bare bones, so,
Yeah, agreed.
And so yes, yeah. All right, so that was just for way of information and to alert you that stuff's coming. And so they're not that interesting, I can tell you, from reading all 100 and some last time, but it's
I can't wait, David.
Okay. All right, so that's that. Okay, the ethics tip line reports, any comments or observations regarding what we see in terms of February and March?
I will say that we're going to be getting these a little bit later than we usually do from going forward, and so you won't have the most recent one on this packet. It'll be on the next one.
All right.
Just because I'm on a roll today, I've got a question. It still feels weird that we get these, and I don't know if it's, again, it's just about naming, about it being an ethics tip line and coming to the Ethics Commission but we get a report and we don't ever really know the substance or do anything with them. I don't know if anyone else feels that way or kind of has that question, but I'm wondering if it's, maybe not for today, because it's already getting late, but to think about that as an agenda item about what the purpose of this, of the hotline is, and is it aptly named, and are we where it should be living? Does that make sense?
It's reviewed by other departments, right? It is.
Kind of passed to, well, it is passed to the Ethics Commission as kind of an FYI, and the report originates from the internal audit. So we can definitely talk to internal audit and see exactly what the life cycle, like where this form is going, who the custodian, because I'm assuming he is the custodian, but I've also learned never to assume anything.
Yeah, and
So-
certainly not wanting to convey it all, like, we don't want to do this, it's too much, like, I don't mean that in a work way, but I don't love the idea that we're sort of FYIing and almost sort of signing off on something. I don't really feel
There's
like I have
no-
substantive information
There's no
about.
additional information, and I think some of these issues that would be showing up as just a number in the tip line report, some of them would be, protected with confidentiality, so we wouldn't even be able to share them. But we'll have a conversation with Chris and see, and it might be worth him having, coming to a meeting and having a presentation or
Yeah.
discussing what those are anyway, because we all just get these papers with numbers
Yeah.
on them.
I think that might be great, and especially, I feel like I didn't have that information when I joined. I still feel a little out of the loop on what our role is in relation to this and how the public's perceiving it. So I would certainly love to hear from somebody who knows.
Yeah, I had the same reaction to us getting these as to the financial interest statements. Officially we get them and hold them, but what are anybody looking at them? So I had the same reaction. So I think it's worth us having a discussion with internal audit as to exactly what this process is like and what the follow-up is and that sort of thing. So, and that actually might be more meaningful than simply getting these documents. So, yeah.
Instead of having if you maybe did it as 2 times a year or even
Right.
once a year as a
Right.
presentation, it might be more meaningful as just to getting a piece of paper in a packet.
Okay, so let's see about that on the next agenda item, if we can set that up, so. And then, getting back to financial interest statements, so we're short of some, and
Yeah, actually, I think this is our best year ever, guys. We're only missing 24 of the regular filers, and we're only missing 6 of the candidates. So that's pretty good for where we are this year. So, yeah, I think changing it to being able to submit electronically has really changed things up for people. So, yeah,
all right?
yeah. But then I put a timeline of going forward. I don't know if the commission wants to approve this timeline, but it would be really helpful if they could, or if somebody could basically give me the go-ahead to send out letters on a rolling basis instead of, having to approve it at every meeting. Just because, I think at the August meeting, if you didn't approve this, schedule, I guess, I would have to wait until the August meeting for you guys to issue orders to appear. And that's really early for.
So do I have a motion that?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Is there any other matter that the commission needs to address this evening? If not, I'll entertain a motion to adjourn. Anybody?
So moved.
Second?
Seconded.
All those in favor?
Aye.
Aye, and thank you for this meeting.